Hello, everyone. Welcome to our webinar. I'm Sandip Chandarana, and we have Kent Holland here as well. Just going to go over a few housekeeping items here. So first of all, we want to thank everyone for joining us. We know how busy everyone is, and we appreciate you taking time out of your busy schedules to spend the next hour here learning about construction phase and professional services risks associated with those. We're very grateful to have the esteemed Kent Holland here, a big supporter of our program. Kent's one of the best in the business, a true expert when it comes to risk management for design professionals. Kent's written many textbooks and has a passion for risk management. So we're honored to partner with Kent, not only on this webinar, but with our overall program. Also our partners, Arch Insurance Company. They are the carrier behind our program here and are sponsoring this event. So very welcome to have them here as well. So as far as the housekeeping items, everyone will be muted during the presentation. If you have any questions, please type them into the questions box. We'll designate times throughout the webinar to answer those questions. We're also recording this webinar, so you will get a copy of this webinar at its conclusion. I think it's next week. You'll get an email. You'll also get a survey, and we'll also provide you with instructions on how to get your AIA continuing education credits. And to be clear, all licensed architects and engineers are eligible for continuing education credit. You'll be provided instructions with that. Any insurance agents, unfortunately, we do not provide continuing education for insurance agents, but for licensed architects and engineers, we'll be providing the CE credits for that. You want to hit the next slide? This is our agenda. We're going to be talking all about construction phase risks. And I'm not going to go into each topic here because we're going to cover them, but you're going to get a full overview of risks associated for design professionals during the construction phase period. And now we're going to talk a little bit about PUA here. So for those of you, this is really mainly for the insurance agents in the room. So PUA, we were founded in 1990. We are experts when it comes to professional liability insurance. That is all we do here. We insure over 1,500 insureds, mainly design professionals and construction contractors. We do over 65 million in gross written premium. The 4 lines of insurance that we specialize in are architects and engineers, design build contractors, miscellaneous professionals, which is really all non-medical professionals, consultants, project managers, construction managers, that kind of thing. We also write excess limits in those 4 lines of insurance. We represent 2 carriers, Arch Insurance Company, which is our admitted program, and we also have Lloyd's of London for E&S business. And so really it's a dual platform where we've got one-stop shopping for all types of risks. So the clean admitted business with Arch, and then the tougher E&S business with Lloyd's. We also work with about a dozen other carriers through our PUA market solutions. And so again, we can find solutions for most risks. And then we do these quarterly webinars as a value add via our PUA University. And one other thing I'd like to mention is our new website. It just launched in conjunction with this website. So it launched about a week ago. Visit PUAinc.com and you can see a nice, clean new website that does have our PUA University, a lot of risk management materials, past webinars, et cetera, et cetera. So with that, I'm going to turn it over to Kent. Again, Kent is one of the best in the business, and we are very excited to have him as our partner here.
Thank you, Sandip. It's really a pleasure to be with you, and I've certainly enjoyed working with you and the PUA Arch program over the years. And I want to just, before we get too far in this, I saw that someone asked a question, how do I get my AIA credit if I'm an architect that's registered with the AIA? And the answer is, if you are a member of the AIA, we need to have your member number and send that to, you'll see on the slide here, it's Julie@constructionrisk.com. If you'll send her your member number of the AIA, we'll go ahead and do the form filing electronically for you. anyone else that wants to have a written certificate, we will send a written certificate of attendance to anyone who sends an email, again, to Julie just asking for that. We'll send it right back to you. Next slide. Okay, this is copyrighted. Next. And these are the learning objectives today. We're really going to focus on the construction phase services. And I have, over the years, found that a lot of the claims arise because of issues during the construction phase where a contractor is, doing something and the design firm gets blamed for it. It might be they're asking for RFIs, change orders, shop drawing reviews, and they are coming in a manner that should give you a clue that there's going to be an eventual claim here. And so we want to look at how do we focus on those issues to manage those. And one of the aspects that we're going to finish up with is job site safety, because again, design firms during that construction phase can really get drug into site safety responsibility if you're not careful. The next slide. Okay, so let's look at the overview. First, we need to understand our risks, and that starts with our contract document. So, if you know me at all, you know that my firm, ConstructionRisk LLC, we do a lot of contract reviews. We really have been doing this for many, many years, and we find that if you have a good contract is really the best way. You start the communication with your client right up front so that you understand each other's expectations. Your client is not expecting more from you than you can logically provide. So the contract document is really setting those expectations. And then the design services, the contract sets the designer's obligations. And so, for example, you're going to see later on in my slides, I'm going to be talking about site safety visits. Well, are you going to be inspecting the project or are you reviewing it? And what do you have to do during that process? And if you're not careful with that language, a court could very well tag you for failing to see a contractor error and failing to tell your client about it. So you need to be careful of that type of wording. When you go through my slides, what you're going to find is I kind of violate the principle that you shouldn't put too much content in your slides. I like to put a lot of words on my slides with the expectation that you can save these and hopefully use these as a long-term resource. So sometimes I'll go to offices around the country and people have notebook binders which have copies of my newsletters and my slides from years before. And so today I've got more slides than I can probably go through. I'm certainly not going to read all the content here. Some of them I'll just say, here's a slide that covers this, and I'll move right on. But if you have a question on these, I'm going to stop periodically and ask you to go ahead and submit questions. And Sandup will go ahead and look at those and read some of those that we think we can answer during the session. If we can't answer them, I'll follow up with an email to you. Okay, next. Okay, so typical design professional construction phase services includes your shop drawing submittal review. You're looking at RFIs. You're observing and monitoring the contractor's work, and do you need to reject that, or do you have the authority to reject it? You're going to be certifying payment. You're inspecting the project for substantial and final completion. And then there are change orders and claims that are coming in from the contractor. And you have a job as sort of an independent moderator to look at those changes and make an evaluation of those. And so you need to be careful how you're doing that. And you'll see in the AIA documents, they have the independent decision maker role. I'm not sure that works very well. I've seen architects agree to that, and I'm not really crazy about that, having somebody else doing it. I just think it's a role that the architect logically should do. Avoid job site safety responsibilities. Next. Okay, the potential liabilities. So the contractor claims that the designer adversely impacted its performance and its cost. And this happens so many times. And the client claims that the designer adversely impacted the project, the schedule, and the cost. And then the other issue is failing to report to the client defective work by the contractor. These are all real issues, but you need to be careful that we don't get overly ambitious in what we're doing. I work with a lot of engineers around the country, and it's fascinating to me how the design professional is so different from a contractor, just fundamentally different in the way their brains work, I think. And so if you tell a contractor, hey, I want you to put an extra 5 screws in this thing over here, another 10 nails, contractor's gonna look at you and say, yeah, how much are you paying me for that? I'm not doing anything unless you pay me for those 5 nails. You tell an engineer, I want you to do this extra service, and they just do it. And so I've had situations where engineers literally have done $1 million in unpaid services without requesting an additional services request. The contract says if they do that, they can't get paid for it because they needed to put in a request for additional service, had to be approved by the board of directors of the university. And I'm like, what are you guys doing? Why are you doing this? And it's astounding to me how designers so often go out of their way to accommodate their client instead of pushing back and saying, wait a minute, there's an issue here. I can't do this without getting paid. There's an issue here. I'm not responsible for what the contractor's saying. You need to respond in writing. And so we're going to deal with that a little bit in greater detail as we go into some of the later slides here today. Next. Okay, so who's going to make this claim? Who are you looking out for? So you've got clients that you are in contract with, and that could be the project owner. You might be working for a design builder, or you might be a sub-consultant to another prime. The toughest client for you as a designer, in my opinion, is a design build contractor. Because when we're negotiating contracts with a project owner, they understand that you're not warranting things, that you can't adhere to an uninsurable standard of care. But when you're working for a design builder, they're like, well, I had to sign this terrible contract with the project owner. I'm going to flow all that down to you. And so the first thing we want to do is look at that flow down clause and make sure that you're not going to agree to do things that you cannot logically do as a designer. Third parties that are not in contract with you may also be potential plaintiffs, and that could be construction contractors, subcontractors, suppliers. And then you've got laborers and site visitors and lenders and sureties. So these are all potential plaintiffs in a claim against you. And then finally, the user of your completed design. And that might be a building visitor, an office worker, a pedestrian, or a driver on a highway that you designed. And some of the suits that we have seen over the years, they look ludicrous, but you end up having to defend them. And if time permits, we can talk about some of those. I do a newsletter, comes out every few months. It's called Construction Risk Report, and it's a free electronic newsletter. And you can find it on my website at constructionrisk.com. And I cover all kinds of cases, and you could go in there and search in the search bar for all kinds of things. It goes all the way back to 99. I've been doing this since 99. Okay, next. Okay, so when do claims arise? Well, you've got contractors submitting change orders that claim increased cost, and they may say, well, this is because of a defective drawing or spec. They may say there's a delay. They say, hey, there were design changes during construction, and that made me have to do more work, and I need to get paid for this. And the owner then might pay a change order to the contractor, and the owner then may try to reclaim its expenses that it paid to the contractor from you, the designer. Now, they shouldn't be able to recover from you unless they show that you were negligent. That's the key. The owner alleges defective certifications for payment. We have several cases like that. And then you have third parties that get injured because there were alleged design errors and omissions. Next. So the real key is a standard of care. And so what we want to say is that the standard of care is going to be this generally accepted standard of care that's used in the industry on projects similar to ours, same circumstances, same time, same place. And so what the courts hold is that in the absence of a special term and condition like a guarantee or warranty, the AE doesn't expressly imply a guarantee or a perfect plan. Liability rests on unskillfulness or negligence and not mere errors of judgment. And this is really important to understand. So I'll see contracts sometimes that have a terrible standard of care, and we need to change that. Other times, there's no standard of care stated, and that might be fine, because where there's no standard of care, the court's going to read in what I just said right here. Expert testimony is what you need to show that you violated the standard or that you met the standard. And I am a program risk manager on projects around the country where project-specific carriers will give a project policy and they assign me to be the PRM. And all those cases, or at least half of those cases, seem to have claims on them. And we hire all these experts to come in to basically demonstrate and testify that, yeah, there was a problem in this project, but we met the standard of care. It wasn't caused by our negligence. And that is really an important thing that you have to maintain. So there's no negligence without a breach of the professional standard of care. And that's why we need to have a reasonable standard. Sometimes I'll see these standard of care clauses that say you're going to act with the highest standard. And it goes on to say, and you shall comply with all the codes and laws, and you shall do all this, and all that's considered standard of care. That becomes uninsurable. Next. Okay, communicate and document. Okay, communicating clearly, promptly to the right people. Okay, so we've talked about negotiating the contract, and then we said don't promise too much or do more than contractually required. And that was the point I made with the engineers, that sometimes do things without getting paid, or they go beyond what the contract called for. And you know, in this business, you know, it's like no good deed goes unpunished sometimes. So you do something, and that creates a problem. So you need to do what you promised, and you need to document in writing any advice that you gave to your client concerning, I'll just give you an example. So you're advising your client, you need to reject this equipment substitution being proposed by the contractor. Well, why? It needs to have a statement explaining that you have an opinion that or equal is not equal, and it needs to be rejected for the following reasons, and have just a short paragraph. And I've actually had several cases where the designer did not bother to give that type of an explanation. And what happened is the owner goes ahead and substitutes the equipment. It didn't work. And then the owner comes back and sues the design firm saying, hey, I'm just a stupid owner. I relied on you. If I shouldn't have done that, you needed to educate me. You needed to explain to me why I should have rejected that equipment. And the courts have said, yeah, they are entitled to that type of an explanation. So you need to do something in the way of documenting that type of thing. Also, if you have a contractor that is constantly papering the file with these emails and these nastygrams that look like they're sort of blaming you for things, they're insinuating that these cost increases are due to your design error, you need to take that and respond to it. You shouldn't just ignore those until the end of the project. They're going to add up and hurt you. So we need to communicate back to our client saying, no, that's not correct. This is what's happening. Next. Okay, documenting the progress of the project. Okay, so we have project websites, we've got BIM models, we've got meeting minutes, reports, email, we have logs of the RFIs and changes, we have photos and videos. And every one of these is a vital piece of information. I've had cases where I was representing a contractor many years ago, and the contractor is making a claim that the designer is holding up all of his work and he can't work. Well, the designer had videos showing that my contractor really wasn't out there working on the project in the areas where it was free to work. And those videos caused us to not prevail on that. So the videos can be helpful. Photos are very important. And when I walk around a project, I'm always taking photos to use later on. The meeting minutes, you know, we have a situation where if you're a subconsultant to a design builder, your contract's typically going to say you can't have any communication directly with the project owner. You can only communicate through the design builder, your client. Well, I've got engineers that are communicating to the design builder saying, hey, this is a problem. This is a problem. I don't like this work. I don't like this work. You need to make this change. The contractor isn't doing it, but they're not letting the owner know that the engineer put that in writing to the contractor. In that situation, you know, you have these monthly meetings where you sit there with the owner and the contractor and the designer. I think that's an opportunity where you can sit at that meeting and say, you know, when we were in the last month, we've seen these issues. We've told the contractor, blah, blah, blah. You're not violating your contract when you have that kind of joint session, and that gets recorded in those meeting minutes. That can be a very valuable tool. Next. Okay, job site safety. I had this toward the end of the slides, and I decided I better put up here because, again, I'm going to run out of time at some point, but I really want to make sure that we've covered this. This is very important. So site safety. it should be the primary responsibility of the construction contractor, not the designer. The design firm contract with the owner should state that you're not responsible for site safety, that the contractor has that sole responsibility. Your only responsibility is to your own employees. And the design professional's activities in the field need to mirror what you say in your contract. So if your contract says we're not responsible for site safety, you don't want to get out in the field and then see something going on and start telling the contractor, that's not safe. I want you to do it this way, because now you violated the terms of your contract. And the court says, well, if you are telling the contractor what to do, even though your contract said you couldn't, well, then you've impliedly taken on that liability. You've taken on that risk. And there are cases where the courts have imposed liability. Next. Okay, so the designers need to really take precaution against accepting responsibility in the field for anybody's work other than their own. Now, there are a lot of court decisions that have addressed the question whether a firm, like an architect or an engineer, has liability for someone else's employee, even though you weren't directly or even indirectly responsible for causing the injury. So the key questions that the court looks at are the contract between the consultant and the project owner. Does it say that you're not responsible? That's number one. If it says that, then that's good. Now we'll go to step two. And step two is, did you do anything when you're out in the field that implied authority beyond what the contract said? So the courts, even though you have a great contract that says you have no responsibility, the court does not stop there. The court will look at what did you do when you went into the field. Okay, next. Okay. The design professional contract with the owner needs to state the limitations on your role. And the field activities need to mirror that. And the contract language clearly needs to state that the consultant has no responsibility. So look at AIA B101, it has excellent language, and AIA A201 has excellent language. And then let's go to the next slide. Okay, so when will the consultant be liable to these third parties? Well, the courts are going to look to the contract, and then even if the contract doesn't create the duty, the court's going to look at what you did in the field. Did you tell the contractor what to do? Did you see a dangerous condition and ignore it? Now, this second point on this slide is one that can catch a designer up, because what happens here is if you see a dangerous condition in the field, but it doesn't create an imminent danger, an imminent hazard, then the answer may be at that point, you should communicate with the contractor or with your client. And if your client is the owner of the project and not the contractor, then you would communicate with your owner, client, and say, look, this contractor is failing to comply with OSHA requirements. They're failing to have people wearing harnesses when they're on the roof. They're failing to put proper shoring in the trenches. They're failing to put proper guardrails on the side of the building that they're working on. They're doing these things. You don't want to tell the contractor how to change it, and you don't even want to tell the contractor to stop doing that unless there is an imminent hazard. Now, there are cases where courts have said, look, it is an imminent hazard. You see somebody in an unshored trench that's basically sandy soil and he's 10 feet down. If that thing collapses, somebody's going to die. And at that stage, the courts have said, look, the designer needs to stop the work. Tell the contractor, stop the work. And if you do that, that's great. You've saved a life. You don't want the court to say, now you are responsible for all the site safety going forward. So I would say you issue a written communication saying, we did this today. We did it to save a life or to stop an imminent danger. We're not doing this in the future. This is a contractor's responsibility. That way a court can't try to impose that liability. Okay, next. Okay, what are the factors that a court will look at in deciding whether you have site safety? They look at, did you supervise and control the work of the contractor? Did you retain the right to supervise and control the work? How much participation did you have in the ongoing construction activities? Were you there every day, or did you just go out every week or two to look at the project? Did you supervise and coordinate subcontractors on the project? Did you assume any responsibility for the safety practices that people were using? And what authority did you have to issue change orders? What right or authority did you have to stop the work? So these 7 factors are what the courts look at. Now, just because you had the right to stop the work, that doesn't make you liable. The court kind of looks at these and they add them all up. So don't look at these and say, oh, I better not ever accept a contract that gives me the right to stop work. That's not what I'm saying, but the court will look at all of these factors. Now, let's look at a couple cases now. Let's go to the next slide. Okay, the supervision of safety is encompassed in the duty to supervise, and no separate agreement to supervise safety is necessary where the architect is supervising the details of every aspect of the project. So this was a decision out of Mississippi where a CM, I think it was found to have been liable for safety because they actually supervised the work. And they didn't have a contract that said they were going to supervise, but their actions created that supervisory function, and the court said, that's enough, they are responsible. Next slide. Now, this one, the CM was not responsible for job site safety. And this is one where the CM contract itself did not specify that the CM had any responsibility for safety. Second, the counterpart construction contract signed by the contractors indicated that they had sole responsibility for their own employees. So this would be like a B101 and an A201. All right, so the B101 for the CM says no responsibility. The A201 for the contractor says, yeah, we the contractors have all responsibility. Well, those contracts expressly disclaimed any direct or indirect responsibility on the part of CM for project safety. Next. So in this case, even though the CM participated, I mean, it actively participated in site safety meetings, it issued site safety reports, it did all kinds of safety related activities, and the court found that all of these were within its scope of the contractually agreed upon service that it was performing, not for the benefit of the contractor, but for the benefit of its owner client. And so the court said, well, that's fine. If the work that the CM was doing was only for the benefit of his client, then that does not make it liable. Very interesting decision there. Okay, next slide. Now, this next one is a case where there was an airport. This was in Boston. An airport maintenance person was electrocuted while he's attempting to repair an electrical transformer. And this transformer was in one of these metal boxes on a wall, or in a, I think it was on a wall. And what happened was the box didn't have the right wiring diagrams and it didn't have the right warning signs. And when the architect had done the punch list with the contractor that built this thing, it was noted that this had to be taken care of on the punch list. And there needed to be warning signs in there. It needed to show what wires went to wire, what was hot, what was not. And the designer didn't follow up when the contractor failed to honor the punch list. He never told the client. He didn't tell the owner client, hey, the contractor didn't do this. So the court said the designer was subject to liability because of its failure to report to its client, the project owner, that the contractor didn't complete that punch list item. And I think this kind of worries me because it means, if you've got a punch list and that punch list has things that might create an imminent danger to someone if they're not done by the contractor, and you've noted that on the punch list, then this would say that you, as a designer, need to follow up on that punch list and advise your client, the owner, whether or not it was all completed. All right. Okay. Next slide. Okay, I'm going to stop there for a minute. Before we go into site observation, I'm going to stop because I've covered a lot of territory and we are about 50% through the time I have with you. And I'd like to ask you if you have any questions on anything we've covered so far. This would be a great time to ask those. I'm going to take a sip of tea. And Sandip, if you've got any questions, please share them with me now.
Yeah, Kent, couple things. So we're going to run a poll right now. We wanted to check the attendee list to see how many AIA members we have. So Ryan, if you want to go ahead and run that poll, that would be great. Secondly, the only question we've gotten so far is if we're going to share this presentation. And yes, you will get a copy of the entire presentation along with instructions on how to get the AIA credits. That will be sent via email early part of next week. And again, if you have any questions, please do ask them in the chat box, and we will break again periodically and answer any of those questions.
Okay, great. Thank you, Sandip. And then in addition to giving them the slides, this is being video recorded and audio recorded. So there's going to be a link to, I guess, a YouTube video, and they can watch this and share it with anybody in their office that wasn't able to attend today as well.
Correct.
Okay, great. All right, then let's move on then. And then if you have any questions as we go on, please put them in your question box, and then I'll stop again and try to answer those questions. Okay, now let's look at site observation. This is an issue that I really focus on in each of the contracts that I review, because what we find is in the old 2007 AIA B101, there was language saying that the architect was doing site observation for the purpose of endeavoring to guard the owner against defects and deficiencies in the work. Well, you know, that creates a situation where you have a duty that you've got to go out and look for. You're endeavoring to guard. How do you endeavor to guard? You've got to look for construction defects. It becomes your duty to exercise the standard of care, to look at what the contractor did and see if there's a defect and report it to the owner. And that becomes a very subjective standard. How do I know whether you're liable when something fell down because you didn't see it and report to the owner that there's a construction defect? And so then we had to get expert witnesses and go in and try to show you met the standard of care. So what happened was the AIA said, this is bad wording, and they got rid of it. And so the AIA language today is much different. It just says you are only going to report what you actually know, known deviations, okay? Defects that you actually observed. And this is a very important distinction. So we make that change. Let's go to the next slide. In every contract. So what you're seeing is the language I've got on this slide, on slide 30, is a B101, and it says, look, what you're going to do is you're going to report what you determine in general that the work is being performed in a manner consistent with your plans and specs. You're not required to make exhaustive or continuous on-site inspections. And what are you going to report? You're going to report known deviations. You're going to report known defects and deficiencies that you actually observe. So this is really important. That's a very objective standard. Okay, so if you didn't know it and you didn't report it, then you have no liability. And the standard of care doesn't say you had to go out there and look for it. It says, did you know it and did you report it? Okay, next slide. Okay, how often are you doing the site observation? So the AIA B101 says you're going to visit the site at intervals appropriate to the stage of construction. The architect's going to provide services that exceed these limits, and if you do that, then you're going to notify the owner if you're going beyond what the services were to be. You're going to be an additional service if you're doing more than one a week or whatever it is. Whatever you've set, then you get paid for that. Next slide. Okay, if the number of site visits is not specified in the contract, then it becomes a standard of care issue. How often should you have been visiting the site? Because the language says you're going to do it as often as appropriate or necessary. Well, now if they're doing concrete pouring, then maybe you need to be there every day to observe that. I don't know. I'm not a designer. I just represent designers. So you would have to have an expert witness say how many visits should you have had. The contract should clearly define, how you're going to be compensated for those site visits, and be careful about sending a junior employee to do site observation unless they're really coached in what they're looking for. And there's a case that I reported on a few years ago out of Austin, Texas, where really well-known architect for some reason designed a couple of townhouses, and the decks on those townhouses were absolutely not built per plans and specs. And had the architect itself gone out and looked at this, he would have seen that these decks were not stable. I mean, this contractor, maybe it was the first thing he ever built, but he didn't bolt the what do you call the ledger board onto the wall of the house. He nailed it with 16 penny nails into the plywood on the house. He didn't have any proper support for the piers. when women got up on the deck for a party when the homeowner first opened the house, the deck collapsed, one woman died, another one's paralyzed. Huge lawsuit. Ironically, the court ultimately said that the architect was not liable because it did not have a duty to endeavor to guard, but only had a duty to report what it actually knew. And so in that case, I don't understand how the court made that conclusion, because the young guy that was out there in the summer as a summer intern taking photographs was putting them in the website of the architect. I mean, anybody could look and see this thing was not built correctly, but the court said, no, architect's not liable there. And you can find that decision on my website too if you go look for that. Okay, let's look at the next slide. Okay, request for information. What's the problem with RFIs? So, RFIs are a very good thing. The contractor has a question. They're going to ask a request for information, and your duty is to respond to that RFI diligently, timely, and you'll find a lot of contracts have a time limit saying you've got to respond to an RFI in 4 days. I normally strike that out and say, 4 days or such a other time is reasonable, because if you commit to a 4-day time period, but the RFI is going to require a serious amount of research to respond to, well, you're still going to have a claim against you by the contractor saying you delayed his work, even though you couldn't logically have responded within the standard of care to that 4-day requirement. So you need to pay attention to that contract language. Contractors are using these to support claims that they are based on changed work, errors and omissions, construction delays. I used to work for contractors before I got into design professional, and my client base was wastewater treatment contractors. And these guys are great, but they're the salt of the earth, and they know how to make a claim. And I had one contractor, and this was way long time ago, I've been doing this for a long time, and this contractor called me, and they were going to have me open up, I think it was going to be case number 25 for them. I said, oh, you got a claim? They said, well, we just won the bid. We're the successful contractor. Meaning, of course, there's going to be a claim. Open a file, Kent. We're going to have a claim. And this contractor made money on every project based on their claims. And one of the things they would do is they would just paper the file with RFIs, just RFI after RFI after RFI. And the designers had a full-time person responding to all these RFIs. The contractor would use the sheer number of RFIs to try to show to the arbitration panel or a court that I had to ask so many RFIs. Obviously, there were design errors. I shouldn't have had to ask for all this RFIs. So be careful in how you're responding to those. The engineer on those projects should have been looking at those and saying, you know what, I'm not going to respond to these 20% because the answers are right in the plans and specs. Go look at it yourself. I'm not responding. That's the answer. Others were RFIs that were simply not appropriate at all. They were asking for things that went beyond what the designer should have even had to deal with. And again, those should have been responded accordingly. So be careful how you're responding. Be careful that it used to be everything was in writing and you had to put a number on them to keep track. Now everything's electronic, it's easier to follow. I like these project websites where I can go and I say, hey, I'm looking at your project, just show me the whole database of all these RFIs and who's responsible. And if I see one that's too long and getting a reply, then I can say, well, where's this? What's happening here? This could turn into a claim, and we need to be aware of this. Okay, next slide.
Hey, Kent, let's take a second here and answer a few questions because
Good.
they're starting to roll in. So from Jason S., he asked, can you comment on the design professional needing to take precautions while taking job site photos? I've been warned to be careful or carelessly photographing activities in the background of my area of focus because if those activities violate OSHA or are unsafe, I may be liable because I saw it, even if I was focused on something else entirely.
Yeah, so that's a very interesting question, and there may be some validity to that, but that doesn't mean you shouldn't take photos. So, I guess everything can turn into a claim for sure, but that claim is probably fairly remote compared to the benefit of taking the photo. So when you're taking photos, I would say you're photographing, what you're looking at. But, I went out to a large hospital project that I'm on several weeks ago. I was taking photos everywhere. And, I'm sure there are things in that photo that somebody might look and go, well, wow, that's an issue. Why don't you do something about that? Well, that's a risk, but it's not a risk that I would say justifies not taking the photos.
Okay, and then Aaron H. asks, can you talk about the difference between notifying the owner about a safety issue and notifying the contractor? Can the
Yes.
DP tell the contractor there is a safety issue without telling them how to proceed?
Yeah, that's a great question. So if your client is the owner, your communication should be with the owner, not the contractor. So, you know, if you see an issue on the project where the contractor is doing something that is not right, you need to provide a written communication to your client saying, hey, this is a problem. You, the owner, need to do something about this. Now, you could also say to the contractor, hey, I see you got workers up there without harnesses. That's okay, but if it's something where you're telling the contractor how to make a change, how to do something to comply with an OSHA requirement, then that can get you in trouble. Even when you're communicating with the owner, and I have two cases where designers were doing historic church work. So they're responsible for renovating these old churches, and there's a contractor on the inside pounding on these walls, and bricks are literally falling off the outside of the walls, and they're falling down on the sidewalk below. And I'm like, the designer came to me and they said, hey, what should we do? I said, well, you need to tell your client that this needs to stop. And so they told the client, the client owner, you need to tell the contractor to stop this. So the owner told the contractor, but the work didn't stop. The contractor kept on doing it. 3 days later, bricks are still falling. Designer comes back to me, what should we do? I said, well, I think at this stage, you need to tell the contractor, stop the work. I said, now, you're going to have a claim. Contractor's going to come in and say, oh, he delayed my work, blah, blah, blah. But it's worth it because you're going to save somebody's life, or you're going to save somebody's Mercedes from getting hit by a brick on it. Do it. So sure enough, they stopped the work. And then, of course, the contractor did make that claim. So that's the risk when you talk to the contractor. You're going to have a contractor trying to make claims for all these frivolous things. Just be aware of that. All right. Let's look on.
Yeah, we have a few more. We'll try to get them at the end.
Okay, good. Okay, so pointers for dealing with the RFIs. Be careful that in your response to the RFI, you don't change the scope of the work, and respond according to the contract. You know, use the time that was allowed. And what do you do if the RFI reveals that there is an error or an omission in your work? Because that could happen. The RFI asks a question, you look at it and go, oh my gosh, there really is a problem. And at that stage, I think that you need to potentially let your insurance carrier know about it, but you need to take it seriously. You need to respond in writing to that RFI. Don't ignore it, but really give it a thoughtful response so that the contractor can fix the problem. And I had a case a few years ago where had the designer taken my contractor's RFI seriously and given a logical response, we could have saved $1 million. Literally $1 million claim came in because the RFI response was like 3 lines long. Instead of taking 2 paragraphs to explain what the designer wanted, 2 sentences long, we made a claim and we prevailed. So, you know, you got to respond appropriately to the RFIs. Let's look at the next slide. I think I make a point here that written responses, concise, unambiguous responses, and then I have some example claims against design firms. Next slide. Okay, let's see. Shop drawings. So we're off of RFIs. Now we're looking into shop drawings. So the architect shall review and approve, take other appropriate action on the contractor's submittals, and it's for the limited purpose of checking conformance with the information given. Review of the submittals is not for the purpose of determining accuracy and completeness of the information. And the architect's review does not constitute approval of safety precautions or construction means methods. Okay, so again, that's out of the AIA B101. You see that I'm citing this AIA B101 language repeatedly. This is an excellent contract form. Every 10 years it gets improved, it gets revised and edited, and the document is really sort of like the gold standard, and it's what my firm uses. And we created our own little template of how we will revise contracts, when we're reviewing them for you, we mark them up, and often we'll use the AIA style language to replace what the owner has in an owner-generated contract. Okay, next slide. Okay, so in this case, a court finds that the engineer is not liable for the means, methods in a shop drawing. So here the engineer approved the contractor's shop drawing that showed a method of post-tensioning a bridge. And the method later was determined to be unworkable and was even dangerous. Well, the engineer's stamp was one of these typical stamps that I have written right here. It says, you know, hey, this is just a sort of a stamp that says almost nothing. Contractor's fully responsible, not us, okay? And then we go to the next slide here. And the court held that the engineer was not contractually responsible for the contractor's means and methods, and it wasn't liable for the errors in the shop drawings, despite having approved those shop drawings. And, you know, one of the things that, you know, I hear people saying, well, should we say we reviewed, or can we say we accepted? What do we do? And I think the courts today say it really doesn't matter what wording you put on there, as long as you've got the right wording in your contract that says your approval doesn't mean anything, and as long as you've got a good shop drawing language that says, you know, when you put that stamp on there, it says it doesn't mean anything, then even though the ultimate thing says approved, they still can't sue you. So that's really the key, is the language. So here, the engineer's contract said, you know, that we're looking at, in general, for conformance with the design concept, and approval doesn't, not construed as permitting any departure from the contract requirements, nor as relieving the contractor of the responsibility for an error or omission. And the court said, well, in this case, the engineer's shop drawing stamp that he put on the drawing and the contract language matched. It wasn't different. It was exactly the same wording. Contractor had no way of making a claim against this engineer. So that's, I find that's very important, to have that good language on your stamp, have that good language in your contract. All right, next. All right. Comply with the contractually established time limits for responding to the RFIs. Use a standardized shop drawing stamp like the one I showed you. Next. Okay, and prior to construction, determine that the contractor's submittal requirements under the contract. So you've got contractually required obligations that the contractor has to give submittals by certain dates. And stay on top of that. Don't let them get behind. Don't review submittals that are for construction means, methods, and procedures. Don't include comments that might be interpreted as changing the scope of the work. And if you reject a proposed substitution, again, like I said before, you need to clearly communicate that reasoning to the owner, so the owner doesn't come back and say, you know, I was able to save $500,000 for taking the substitution. You needed to really explain to me why I should have given up that savings and stuck with the original brand name. Why, you know, it's like a court will go, yeah, you have to do that. All right, next slide. Okay, timeliness, B107 again. The architect's action shall take place in accordance with approved submittal schedule, and the design firm should verify that the timing provided in the construction contract is consistent with your own timing under the standard of care. As I mentioned before, when you're looking at RFIs, you don't want to agree to review RFIs or shop drawings in a really short period of time. You need to have a reasonable out. Maybe what you do is you say, look, we will respond within 4 days to tell them whether we can give them an actual answer, but we'll at least respond saying, we got your shop drawing request, standard of care requires we're going to take longer, and that would be fine. So be careful what you commit to in the contract, and if you commit to it in the contract, then you better honor it, or you're going to see claims. Okay, next slide. Okay, it's similar to RFIs. Avoid making changes in your design by approving shop drawings. You know, it's like contractors complain that through the rejection and comments on shop drawings, the architects are changing the design. Be careful that you don't do that. Review is to determine that the shop drawing meets the information given and the design concept expressed in the contract documents. Next slide. So there's no substitutions via submittal. So the contractor may make substitutions only with the consent of the owner, after evaluation by the architect, and in accordance with a change order or construction change directive. And so too often I am seeing these contractor submittals, a shop drawing submittal that's offering an or equal instead of the brand name. And the designer didn't pick up on that, and they may even approve the thing. And then the contractor comes and says, "Oh yeah, they approved this substitution." Well, no. The only way we could approve a substitution is if you'd come in and notified us that there was this change. You didn't balloon it. You didn't show anything. How are we supposed to know you had changed this? And the only way it can get changed is through a change order. So again, if you object that substitution, just give your reasoning. Okay, next slide. Okay, so what if the owner overrides your opinion regarding the substitution? So you've now given the owner a brilliant explanation for why they should not accept this or equal equipment. And the owner says, "No, I want to save that $500,000. So B101, again, has really good language. Says the architect shall not be responsible for an owner's directive or substitution that's made or given without the architect's written approval." So I've seen situations where the owner comes back to the architect and says, "Well, we want you to approve this." And the architect says, "No, I can't approve that. I told you, don't accept that equipment." And the owner's like, "You have to sign off on this." Well, at that point, you need to work with your attorney, get your attorney involved, and say, "Look," to the owner, I can't agree to this. I'm going to adhere to this B101 3.14 language and put something in writing saying, "You've told me I've got to accept it. I'm accepting it basically, but I'm not really accepting this change because I've told you it won't be as good as what I specified." So you need to do something in there that will protect you against that client who is insistent on your ultimately signing off on this substitution that is not good. One thing I don't think I have in my slides here today is, what do you do when you have a client that says, "Well, I want you to do something that doesn't meet code"? And I think I had a question came up from an architect last week. I don't think I've answered it yet, but that was their question. Their client wants them to do something that's going to save money, but it literally doesn't meet what the code requirement is. And the architect wants to know, well, can I do that? And can I have the client sign an indemnity language saying, well, if I do what the client's telling me that doesn't meet code, the client will indemnify me if anything goes wrong? Well, my response is, that's not probably going to work. If you do something as a designer that does not meet code, and it doesn't meet code, my belief is that you will be liable for that, no matter. And that indemnity, a court might look at that and say, well, that's contrary to public policy to allow you to be indemnified for having done something knowingly contrary to code. So when you have a code compliance issue, you need to protect against that issue, just like you do the issues that we're talking about here. Okay, next slide. Okay, change order reviews. Okay, so change order reviews, you are sort of an independent decision maker when it comes to reviewing change orders. And so you need to be able to look at that and advise your client yes or no. And you need to be careful again about contract language, because I'll give you an example. AECOM, the big engineering firm, was sued by a town in New Hampshire about 6 years ago, and I wrote an article about it in my newsletter. And the contractor put in a change order request. It was not a good change order request, and AECOM said to the owner, "Yeah, this is bogus. Don't accept this change order request. They're just simply misinterpreting my plans and specs." So the contractor denied the change order request. Then later, the contractor filed suit against the owner. Well, normally what you want to do is, you as a designer want to be working hand in glove with your owner client to defend against that. In other words, I don't mean you defend it. I mean, you're providing the expert guidance to your owner to know how to defend that claim. But what happened in that case was the owner says, "Hey, I've got this indemnity clause, and it says that the designer has to indemnify me for all claims and damages, etc. And this is a claim, and so I want you to indemnify me." And the court said, yeah. Not only does the AECOM had to indemnify the owner, they even had to defend the owner against that claim. And this was just a run-of-the-mill contractor claim. Unbelievable. So, and that was because the indemnity wording wasn't limited to third-party claims. The court said, well, it didn't say only third-party claims. It applies to first-party claims for damages. And the duty to defend it and say, anything about, professional liability, it's just every kind of claim. So be careful of that. Okay, next slide. And this one is, don't execute change orders stating changes were necessitated by design errors. Now, what I mean by this is, what I'm finding on some projects is that owners are using these forms. They must have some outside vendor form that has been created. It says, well, why are we granting this change order? Well, because it was an owner change, it was a contractor change, or it was a design error. And I don't like that design error box. And so I've advised designers when they see that, be careful. Do not agree to that. I've had one where the owner wouldn't change that box, so the designer had to, every time they did it, they had to put their own little language on there saying, we're signing this, but that doesn't mean we're agreeing to liability. Whatever this design issue was, we were not negligent or didn't commit a negligent act or omission, to clarify that. Otherwise, they could come back and say, well, you've admitted right here that you were at fault. Okay, next slide. Okay, analyze the contractor's claim for entitlement. And this is really important. If a contractor makes a claim, I think you as a designer need to take seriously that you've got to do an analysis, not only of what are the damages, but what is the cause, and is the contractor entitled to any recovery? That's your role to advise your client. And I've seen situations where, contractors have made really outrageously bogus claims, and it gets passed right through to the owner. And that shouldn't have been done that way. The designer should have said, no, this is not a valid claim. This should not even go to the owner. All right, next slide. Okay, reject the work, stop the work. Okay, this whole issue of, do you have the authority to reject the work? And the B101-27 says you have the authority to reject work that doesn't conform. Some people say, no, I don't want to have that authority. I just want to have the authority to tell the owner it doesn't meet the standards and they should do it. I think that the thinking today is, if you have that authority to stop the work, that doesn't make you necessarily liable. So, okay, next slide. Okay, next slide. Okay, certifications. Okay, be careful in your certification language. And we're kind of coming up to the end here, but this slide, what I want to make a point here, the AIA has, again, really good language, and it says the architect's not going to be required to execute any certificate or consent that would require it to have knowledge, service, or responsibility beyond the scope of this agreement. And what that says is, if you're only out there looking at the site during construction once every 2 weeks, how in the world could you certify that the contractor met every plan and spec that was out there? You can't do it. And so I'm finding lender certifications, I'm finding owner certifications saying you've got to certify everything that's done by the plans and specs. I'm like, no, we're not going to do that. We had language saying we don't have to do it, and we're not going to do that. And so I changed the wording in those. And normally we get that changed. Next slide. Okay, so this one says, upon completion of the construction, the designer is going to certify that all the work was completed in accordance with plans, specs, and drawings. You don't want to ever do that. What you want to do is fix it by what I have on the next slide. You're based on your professional opinion or to the best of your knowledge, information, and belief, the contractor met the requirements of the plans and specs. That's all you can say. That's not a warranty. You're just saying, look, based on what I could tell, they did. It gives you that wiggle room, if you will. To the best of our knowledge, information, belief, the project was constructed in general conformance with the design concept. Not bad. Okay, next slide. Conclusion, stay focused. And that was me sitting in my office working while the window washer is washing the window right outside of my office. I thought that was pretty good. Okay, next slide, questions, okay? And go to the next slide after this one. And the next slide. Okay, that's how to get a hold of us. Now, Sandip, while that's on there, do you have any questions here?
Yeah, a couple things. So great job, Kent. Really appreciate it. For all of those in attendance, one of the value-added services of our ARCH program is you get unlimited contract reviews from Kent. And Kent also mans our 1-800 toll-free hotline for risk management questions. So if you're an ARCH policyholder, you get access to Kent, and we widely encourage our insurers to use Kent services. It's a win-win. It helps you mitigate your risks, which theoretically will lower your loss exposure, which will result in lower premiums. And for us on the underwriting side, it improves our results. So we strongly encourage that. And like I said, Kent is the best in the business. You will get copy of the recording, the slides, everything next week. And it looks like we're right at 3 o'clock. We did have a few questions we didn't get answered. So what we will do is Kent can answer those directly to the people that ask the questions here through the chat hotline. And again, if you have any other questions, you have both of our information there. Feel free to reach out anytime, whether it's regards to this or any other questions. We're here. We're happy to help.
Thanks. Okay.
Awesome. Thanks, everyone. Have a great rest of your day. And again, we appreciate you taking the time out of your busy days to spend an hour with us.